Not only was he a teacher, a great lawyer, a great mediator, and not only that, the person who negotiated the Lucasville riot case that is sitting here right now. But he's also,
as one of his former clients told me yesterday, he provides great comfort to people in the darkest of times. Much of what I know about being a lawyer, I learned from my dad during the 20 years that we practiced together. Part of that education consisted of the nuts and bolts of the law, but I think an even bigger part centered around the relationships of law. As we all know, the practice of law can be contentious, but my dad taught me that the lawyers don't have to be.
I went to a very good law school that in the intervening years has become an outstanding law school. We like to refer to it as the Ohio State University. But far more important than what law school you went to in the development of a lawyer is who your early mentors were. And I was blessed with incredible early mentors. First, Jack Day and Bernie Berkman. By the way, every time I hit a good story, I'm on a detour to tell the good story before going on. Bernie Berkman and his brother-in-law, who was a partner in the firm then known as Berkman, Gordon, and Kanzelbaum, Josh Kanzelbaum, got in an argument about the merits of a professor they had had at Western Reserve Law School. Bernie really liked him and Josh really didn't. And Bernie said, he was my mentor. And Josh said, he was my Painesville. Another incredible, one of the most incredible mentors one could ever have was Jerry Gold. And there were a multitude of things that I learned from Jerry, but two that are foremost. One is people relating. Jerry was and is a superstar at people relating. Everybody loves Jerry, and he can accomplish an enormous amount because everybody loves Jerry. Illustration, he could cross-examine a cop within an inch of his life and still have the cop like him afterward. That's talent. The other thing that I learned from Jerry, of many things, was the use of humor as a means of diffusing tension and of making people comfortable, and there's none better than Jerry Gold in that arena. Another mentor, another partner in the legendary firm of Gold, Rotatory, Messerman, and Hanna was Jerry Messerman. And Jerry Messerman was one of, if not the very best trial lawyer I ever saw. And enormous number of talents, but the thing that made him incredibly good was that he understood the three fundamental principles of litigation. Now, you know the three fundamental principles of real estate: location, location, location. The three fundamental principles of litigation: credibility, credibility, credibility. And his laser-like focus on credibility is what enabled him to win what would look to everybody else like impossible cases. I would be remiss if I didn't mention one other mentor. Now, her name was Ccw Schwartz. Now, you probably don't know her. She was my mother. She was a pre-law mentor. And she had a standard of ethics so fierce that if applied to Ohio lawyers, we would all be disbarred. And one of her many fundamental principles was the importance of keeping your word. And there's a little story that illustrates that. I was about 8 years old. She had told me she would take me to a parade that was going to take place on North High Street up by the campus. Well, the day of the parade came around and it's pouring. And she said, "I'm sorry, Nikki, but because of the rain, there isn't going to be any parade." I said, "But Mommy, you promised." She said, "Well, sorry, but there isn't going to be a parade." "But Mommy, you promised." Now, at this point, most parents, including me as a parent, would have said, "Shut up, kid, there ain't gonna be no parade." Not Faye Schwartz. We put on our raincoats, our rain hats, we walked to the end of the streetcar line, we didn't have a car then, and we took the streetcar all the way up to North High Street, where the parade was going to be. Well, of course, there was no parade. There was water in the street up to the curb. It was pouring. We took off our shoes and socks and we danced in the water in the street. And we came home and I never saw the parade. But what a powerful way to teach a little kid the importance of keeping your word. I was blessed with an enormous variety of experiences in the practice. As a professor, I spent 3.5 years as a law professor because although I didn't want to start that way, the job that I really wanted, being attorney in the Civil Rights Division, the Justice Department in the middle 60s, where it was so important, fell through at the last minute. That's a very interesting story, but a whole nother day we'll have to do for that one because it's a long story. But one of the consequences of starting out as a law professor, even though that wasn't my preference, is that 4 years later when I arrived in Toledo as a rookie lawyer, and I was a rookie lawyer, I wasn't treated like a rookie lawyer. Everybody treated me like a former law professor, even though I didn't know any more about practicing law than the first day rookie without teaching experience. So the breadth of the spectrum of practice can be illustrated incredibly wide in time. Two cases will illustrate in time. My first prison case was filed in October of 1969. The court finally relinquished jurisdiction in August of 1991. The case lasted with some dormant period in between, but basically lasted more than 21 years. By contrast, I represented Broadway Productions, which had contracted with the city of Cleveland to put on a Broadway show called O Calcutta at the Music Hall. Well, O Calcutta featured, among other things, frontal nudity. And when Mayor Perk, who was in a campaign for re-election at that time, discovered that the city auditorium was about to be used for a show with frontal nudity, the city refused to go through with the contract. And that's when I came to represent Broadway Productions and filed an action for temporary restraining order, preliminary injunction, and permanent injunction to compel the city to allow the show to go on First Amendment grounds, and it got assigned to that greatest of all judges, William K. Thomas. And the suit was filed one day, and the TRO hearing was consolidated with preliminary injunction and trial on the merits the next day. So 24 hours from the filing of the case to final judgment. A lot of room in between. A lot of variety in space. I talked about time, now I'm talking about space. I appeared in courts all the way from the Mayor's Court of Monroeville, Ohio, to the United States Supreme Court. And that was in one case. It was a case in which our firm represented a magazine for truckers. And they had a litigation program. They felt truckers were getting ripped off by small town mayors on major highways, and they wanted to abolish mayor's courts. So we were tasked with putting together litigation that would result in mayor's courts being abolished. So I used the trial, such as it was, to develop the evidence necessary to demonstrate that a mayor who, as chief executive officer, was charged with responsibility for fundraising could not be a fair and impartial judicial officer in determining guilt and innocence and assessing fines, when 40% of the general fund came from mayor's court fines. In addition, there was one police officer appointed by the mayor, and he was going to be required to sit in on his credibility. So it was a Saturday morning, and I was driving over to Monroeville, which is a little village about 10 miles west of Norwalk on Route 20, for what was going to be the trial. My wife's little brother from Baltimore was visiting. So I said to him, I said, Jimmy, I told him what I was doing, would you like to go along for the ride? He said, sure. So he went along. We get there. The trial takes place in the back room of the village hall. The mayor's office, which is minuscule, barely has room for the 6 people who were going to have to be there, including the mayor in his undershirt, me, the village solicitor, the defendant, the witness, and the court reporter I brought, as well as the only spectator, my brother-in-law. Now, the operative burden of proof can be illustrated by a brief excerpt from the transcript. After I had moved to dismiss the case or certify it to another court where a fair and impartial judge would be sitting, and that was overruled, the judge said to me, Mr. Schwartz, all right then, given the overruling of the motion, we will enter a plea of not guilty to the charge. And he says to the defendant, Mr. Ward, a plea of not guilty has been entered in the charge. Did you wish to offer in the way of testimony anything at this time? I said, well, there's been no testimony offered on behalf of the village yet. Mayor said, I see, we will proceed. And we began with the appropriate order of proceedings, with the prosecution presenting its evidence first. Well, fast forward, in the case then, we appealed all the way up through, I argued the case in the 6th District Court of Appeals in Toledo and in the Ohio Supreme Court, and in the case worked its way up to the United States Supreme Court, where the United States Supreme Court held that the mayor could not be a fair and impartial judge under those circumstances and reversed the conviction, but didn't do anything that resulted in the abolition of mayor's courts. Rather, what happened was that anybody who's in a mayor's court and wants to contest the case has a right to get it transferred to another court. But that really doesn't solve the problem from the trucker's perspective. But anyway, the case became a semi-landmark case on fair and impartial tribunal, included in a number of constitutional law case books, including the one being used at the Yale Law School, when little brother Jimmy is now a student in the constitutional law class. And he's called on to recite by what sounds like one of those tough guy Kingsfield type law professors. And he gets up and recites, and the professor says, wait a minute, those facts aren't in the opinion. Where'd you get those facts? Jim said, oh, I attended the trial. The most memorable case that I was involved in that area was a case in which we had sued to enjoin the city of Youngstown from closing down a movie theater in which the Swedish film I Am Curious Yellow was being shown. And the case, under the rules at the time, was heard by a 3-judge federal court. And I Am Curious Yellow was fairly tepid by today's standards, but it was a little racy then. And one of the things I can tell you about obscenity litigation is if you want the sex scenes to feel like they're lasting forever, watch the movie in the presence of 3 federal judges. The other anecdote from that case was in the final argument before the 3 federal judges, who were pretty stern for the most part. A prosecutor from the city of Youngstown had very great difficulty pronouncing the word cunnilingus. And there was frequent occasion to use that word in the course of the oral argument. And he never got it right. Cunnilingus, I can't even remember all the permutations. But in closing argument, it came out congolitis. And 3 federal judges started rolling on the floor. The other area of more exotic practice than the 6 common categories was prison litigation. The case that lasted 21 years. It involved practices and rules and procedures and conditions and practices at the Marion Correctional Institution called J.B. Taylor. Another case was a case in which I was asked to file litigation to attempt to compel the closure of the old Ohio State Reformatory at Mansfield on the ground that it was unfit for human habitation, which it was, and which ultimately, after a great deal of effort, resulted in the closure of that facility, which enabled it to be used as a set for the Shawshank Redemption, during which I recognized every square inch of that prison because I'd been through it with all kinds of experts. Those experiences led to my being asked to get involved in the Lucasville prison riot to represent the rioting prisoners in the negotiations. That's a whole story in and of itself, which I have to save from today. But 2 days after I got involved, the riot settled with the prisoners surrendering peaceably and releasing the remaining hostages without further harm. The media gave me all the credit. I deserve some, but not all. Gave me all the credit. And in one of the feature stories about my background, it talked about the J.B. Taylor case, which I told you about. And this, as I said, this settled 2 days after I got involved, and the paper said, evidently Schwartz has learned how to work faster. Now, I always thought that I was underrated as a lawyer before the prison riot. Since the prison riot, I know that I'm overrated as a lawyer. Okay, now back to bet the company litigation. Okay, well, that refers to litigation in which so much is at stake that the fate of the company rests on the outcome of the litigation. And I not only was selected in that category for several years running by Best Lawyers, but in 2009, they named me Lawyer of the Year for Bet the Company litigation. And they called to interview me then because they were doing a little feature story on the various lawyers who had been selected as Lawyer of the Year. And I said, well, I'm really honored to be selected, but a couple things I have to tell you. Number one, I've never handled any litigation that could remotely be described as risking the fate of the company. And what's more, I don't believe in it. Nobody in their right mind should bet the company or anything they really care about on litigation. They ran that in their little story about my having been selected. And what do? 2013, 4 years later, again I was selected as Lawyer of the Year for Bet the Company litigation, still not having handled the first such case. Now, why don't I believe in betting the company on litigation? Well, that's part of this, what they didn't teach you in law school, which I'm about to talk about. When I was teaching, I had a dean. Carl Craston was his name. A good man and a good dean. Had gone to Western Reserve Law School. His best friends had been the legendary Bill Carnation Willie Krause. Few of you would have known him. You may know his sons, Ken or Keith. And his other best friend at the time was a man named Don Young, who became the longtime federal judge in Toledo. Anyway, Carl chafed under an autocratic dean when he had been a law professor at the University of Florida. And he vowed if he ever became a dean, he was going to run a democratic operation. So the faculty was consulted and voted on everything, including what flavor finger sandwiches to have at next Friday's tea. In terms of hiring, who was going to be hired and who wasn't for the faculty of the law school. Now, Carl deferred to the will of the majority, but he wasn't bashful about expressing his views on the subject. One of his views was that he didn't want to hire anybody who had practiced for more than 5 years. Because, he said, they would be so cynical they wouldn't take doctrine seriously. I didn't understand that then. I now understand it very well. And that's where we go from here. So let's talk about a few of my cases that illustrate these propositions. And let's start with my very first time in a real court. When I got to Toledo, I wanted to meet some Toledo lawyers. I wanted an opportunity to do some kind of practice since I was going to be teaching and hadn't had any practice experience. So I went to a luncheon meeting of the ACLU Legal Committee. And they gave me an appeal to handle. And it was an appeal of a young man, a socialist, who had been arrested on the Bowling Green campus for selling socialist literature for 25 cents without a Bowling Green peddler's license. And he had been convicted by the mayor, and somebody else had appealed it. The county court was just, gave short shrift. And so the appeal now was at the Court of Appeals level, and that was what I was going to handle. Well, I was not teaching that summer because of my juniority, summer teaching being highly valued because you could earn more money by teaching in the summer. So I had an abundant amount of time to do two things. One, prepare my con law course for the fall, and two, write the brief in the appeal from the Bowling Green Mayor's Court. Something that busy practicing lawyers don't have the luxury of having that much time to write a brief. So, I wrote the definitive treatise on First Amendment law. The Bowling Green Ordinance was a checklist of every conceivable First Amendment defect an ordinance could have. And comes time for the oral argument in the Court of Appeals. And I walk up to the podium loaded for First Amendment bear. Before I could open my mouth, the Chief Judge says, "Well, counsel, before you start your argument, we have a question we would like you to answer." He said, "Do we have a valid bill of exceptions in this case?" I didn't have the faintest idea what he was talking about. So I nicely said I didn't understand the problem with something. So he explained that the trial transcript, which in that era was called the Bill of Exceptions, had been forwarded from the trial court without being signed by the trial judge. And I said, well, I didn't know what the consequence of that was, and asked for leave to file a post-argument brief, which I think he gave me 7 days to file a post-argument brief. So I said, okay, now you can go on with your argument. Well, he had let all the air out of the balloon. Neither the court nor I were focused on First Amendment. I was thinking about whether the Bill of Exceptions was valid and all that kind of stuff. So it was a real anticlimax. So immediately after the argument, I run for the law library. And I don't know why, but I remembered a phrase from law school. The phrase was nunc pro tunc. And I went to OJUR, which normally has a terrible index, but lo and behold, nunc pro tunc was in the index. And it led me to a 1913 decision of the Ohio Supreme Court called Cincinnati Traction Company versus Ruthman, where the absolute identical thing had happened. And the Court of Appeals had dismissed the appeal for want of a valid bill of exceptions, and the Supreme Court had reversed the Court of Appeal and said, the remedy is not dismiss the appeal, send it back to the trial judge to sign nunc pro tunc. How many times in your career do you have a case where you have an Ohio Supreme Court case that's actually on all fours in every respect? Very rare. Here, I got it in my first case. So I'm now comfortable with having solved that problem. I get an order in the mail. appeal dismissed for want of a valid bill of exception. In total disregard of the Ohio Supreme Court decision directly in point. So I appealed to the Ohio Supreme Court. Now at that time, the Ohio Supreme Court had oral argument on the motion to certify. In other words, you would go down and argue for 15 minutes on whether or not the court should hear the case, and then if they granted jurisdiction, then you would go back down later after the briefs on the merits were filed and argued the merits. So I went down in Cincinnati Traction Company versus Ruthman, and the court summarily reversed without taking it in and requiring me to come back and argue again, and remanded it to the Court of Appeals for them to decide the case on the First Amendment merits, which they did, upholding the conviction and upholding the constitutionality of this ordinance. And so what did I do? I appealed to the Ohio Supreme Court again. Now I'm back down arguing on the motion to certify, and they agreed to hear the case on the merits, and so then I went back the third time to argue on the merits. And so my very first case ever, I argued 3 times in the Ohio Supreme Court. Now you may wonder, how come we don't get arguments on motion to certify in the Ohio Supreme Court? Well, you can blame Jerry Messerman for that. At the time that I was teaching at Toledo, Jerry was teaching at the Ohio State Law School and running a post-conviction clinic. And he noticed that prisoners who were represented by counsel, their counsel got to argue the motion to certify in front of the court itself. But for unrepresented prisoners at the old Ohio State Penitentiary on Spring Street, the court would send over a law librarian or somebody to act as a special master and hear the argument. Messerman filed objection, denial of equal protection. Court solved that problem. They abolished the right for everybody. All right, so I argued the case on the merits for a very conservative Ohio Supreme Court on behalf of a young socialist urging the unconstitutionality of the Bowling Green Peddler's License Ordinance. And the decision comes out, and I win 7-0. Striking down the ordinance, reversing the conviction, and I thought, wow, I must be really good to persuade this very conservative court to reach this outcome here. Well, a couple years later, I met a lawyer who told me that he had clerked for the judge who wrote the opinion, and that immediately after the oral argument, the court had convened to deliberate about the decision on the case, and voted 7-0 to uphold the conviction and uphold the ordinance. And his judge was assigned to write the opinion. And so his judge sent him to the library to do the research and write the opinion. He, doing the research, concluded that I was right, went back, persuaded his judge to that effect, and his judge persuaded the rest of the court, and so it came out as a 7-0 decision the other way. But it wasn't the brilliance of my argument. On a much smaller scale, Gold once sent me out to a municipal court for a preliminary hearing, in the old days when we actually had preliminary hearings. And preliminary hearings were really, it didn't matter much because the prosecutor could go to the grand jury to get an indictment even if it wasn't a bind-over. And defense lawyers most often used the preliminary hearing for a discovery device, since Rule 16 allowed precious little discovery at the time. But Gold said to me, this is a case where I think there's really a good argument that there's no probable cause. And and if we can get the court to deny the bind-over, there's a chance it might go away. So I went, gave it my all, and made what I thought was a very compelling argument to the court that there was no probable cause. What did the court do? It bound over the defendant on a finding of possible cause. On the record, possible cause. The next case I want to tell you about was an assigned CCW case. I probably made the mistake of going to court with gold one morning, and the judge assigned me this case. And it was a 20-something guy charged with CCW. I went to the first pretrial. He didn't show. And the judge issued a capias. And the better part of a year went by before I got a call that he had been arrested. And the court was now going to proceed with the case. So I go over and I meet him. And he wants me to get him out on bond. And I said, you didn't show up. You had to be arrested. You were gone almost a year. This judge is not going to let you back on bond. He insisted that I make the motion, which I did in a fairly perfunctory form, and as expected, it was denied. He then declared he didn't want me as his lawyer. He wanted a different lawyer. And I said, that's fine with me. You can't do a good job for somebody who doesn't want you as their lawyer. And so I filed a motion with the court for the appointment of new counsel. Denied. So here's unwilling lawyer and unwilling client locked together for this CCW case. And we begin, first, of course, comes after jury selection, opening statements. And the court says to the young prosecutor, Ron Adrian, Mr. Adrian, would you like to tell the jury what your evidence will show? He gets up, gives his opening statement. Then she says to me, Mr. Schwartz, would you like to tell the jury what your evidence will show? I said, Your Honor, may I approach the bench? I said, Judge, I object to being asked in the presence of the jury to tell the jury what our evidence will show. The defendant has no burden to produce any evidence at all, and doing that calls attention to the fact that he may not be producing any evidence. Overruled. I said, well, could you ask the court reporter to come over so I could put that on the record? No, don't bother me. So, a good lawyer, when the door closes, tries to figure out a way to come in the window. So, I thought, well, I'll go over at recess and give the objection to the court reporter. Comes recess, I walk toward the court reporter and I hear the judge screaming, no proffers, no proffers. Court reporter wouldn't take it. So, when they close the door and close the window, you try to think of ways to come down the chimney. And I figured, well, I'll get to the end of the case, I'll file a motion for new trial, and with my affidavit attached as to what happened and the grounds for the motion for new trial. So he gets convicted of carrying a concealed weapon and sentenced to a couple of years, I think, at least, if not more. And she says to him, I know you were not happy with Mr. Schwartz, so I'll be happy to appoint a different judge for you for the appeal. He says, oh, no, Mr. Schwartz will be fine. He saw me fighting with her on that issue, and so he decided I was okay. So here I am now. I'm an appellate counsel as well. I filed my motion for new trial with my affidavit as to what had happened. But when when the transcript comes back thereafter, it has her saying, now, Mr. Schwartz, would you like to tell the jury what the evidence will show? Which cures the objection. I called the court reporter. I said, did the judge call you in and question you about this part of the transcript? Yes. Wouldn't admit that she had asked him to change it, but it was pretty obvious that that's what had happened. So one of my assignments of error was being asked to tell in the presence of the jury, to tell the jury what our evidence would show. And I just happened to get a panel of the Court of Appeals, which included Jack Day, who had a pet theory about how to deal with problems this, which is nobody else ever heard of, but he calls a bystander's bill of exceptions, which is you find somebody, bring him in from the hall, and you give your objection to the bystander. Well, first of all, and he wanted to know why didn't I do that. Well, there are two reasons. One, I didn't think of it at the time. And two, I would have been in chains if I had tried to do it. So the court goes ahead and affirms the defendant's conviction, overruling the objection on the ground that the transcript doesn't support the objection. Next case, a fairly garden variety age discrimination case in federal court in Toledo, where there's ferocious opposition from one of these national mega firms that represents employers. The case featured more Rule 37 motions than all the cases in the rest of my career combined. It was just a nightmare from beginning to end. And I remember getting ready to drive over to Toledo for the trial. And I felt like a friend, Ralph Spurley. Some of you may remember Ralph. He was a former prosecutor and then a defense lawyer. And he was a regular at our lunch table at the theatrical. And there would be times when he would be dreading an upcoming trial. Now, criminal lawyers aren't afraid of losing because they do it all the time. The dread of a criminal lawyer is getting to the end of the evidence, time for closing argument, and having nothing to say. So Ralph would say, on occasion, he'd be lamenting the fact that he has this trial coming up, and he said, and I'll have to paraphrase, that he would commit fellatio on public square not to have to try this case. And I felt that way driving over to Toledo for this case. Well, as fate would have it, everything went spectacularly well. I demolished their witnesses on cross-examination. My client was not the disaster as a witness that I feared he would be, and we won everything. And here's the magnitude of the win is that the jurors, after the decision was rendered, the jurors came over to my table and asked for my car. So I chalked this up as a win. No, not so. The other side files a motion for new trial. Why a motion for new trial and not a motion for judgment NOV? Well, because the granting of a motion for new trial on the weight of the evidence is not appealable. You have to try the case the second time before you can appeal whether granting a new trial on the weight of the evidence was appropriate. And there's no way if he had granted judgment NOV that it would have held up. And they had a new name on the motion. And the new name was a big firm lawyer whose longtime secretary had become the secretary for the judge recently. And so the court grants the new trial. We go to the new trial. This lawyer who was added to the case does nothing but except sit there through the case. And the company doesn't bring back the witnesses who got destroyed, brings some new ones with new stuff and so on. And the long and the short of it is that we ended up with a defense verdict on the second time around. And I was so mad I appealed it all the way to the Sixth Circuit and the U.S. Supreme Court, even though I thought very little chance that it was going to happen. The next case, a wrongful discharge case on behalf of 8 employees against a powerful company and a powerful union. and 8 employees had been discharged for turning in inflated motel receipts for reimbursement. And the union had done nothing to really investigate or prepare a case for the grievance, and just went to the grievance and said they're not guilty without any support. And of course, the grievance was denied, and their discharges were upheld. And so what all that remained was a suit for breach of the duty of fair representation against the union and wrongful discharge against the company, and the law required that you had to win both in order to win either. I asked the lawyer who had referred this case to me, who was in Buffalo, to go over to the hotel in question to investigate. And he calls me and he says, "You're not going to believe this, but I'm talking to the clerk, who tells me that the men paid what the receipts said they paid, that he wrote down less and pocketed the difference." I said, "Is he willing to testify to that?" He said, "Yeah." So, took his deposition and he did testify to that. And in fact, he also testified to the fact that during the grievance proceeding, the company had brought him in from wherever he was, and he had told them the truth then, and so they put him in the car and sent him back without having him testify or disclose. So, so that's the way discovery developed, and we get to the go through again a fairly bitter fight, and the court ultimately denies the motion for summary judgment after 3 years of discovery and motion practice. And case is set for trial 3 or 4 times in the ensuing year, and somehow always gets continued over my objection. And about a year later, the defendants file a new motion for summary judgment. New only in the respect that it's on new paper. There's been no new evidence, there's been no change in the law, same thing. This time the court grants it. I was devastated. I had 3 years invested in this case. It was the only case of substance I had brought with me from my old firm to my new one. I wanted to go back to the office and burn the law library. It so happens that I had a pretrial in that judge's courtroom the next day. And I'm sitting at a recess, I'm sitting at the trial table, and the judge comes up to me and he says, "Niki, how are things?" And I gave a kind of non-committal grunt, and he gets in my face and he says, "How are things?" I said, "Well, Judge, this hasn't been my favorite day." He said, "It hasn't been mine either." How did I interpret that? Nobody gets to be a federal judge without owing somebody for having gotten them there. And if somebody is strong enough to get to that somebody, and that somebody is willing to take it up with the judge, the outcome can be effective. The criminal equivalent of the sending the motel clerk back to the back and put him in the car and send him back without bringing him out occurred in a case where a young man came to me. He had been convicted of a homicide, and he came to me. He was out on bond pending sentencing, and he came to me, and I said, "Well, what happened?" He said, "Well, I was at the Greenhouse restaurant, got in an argument with a guy, and I went outside and left and went home." I said, "Well, where's the homicide?" He says, "That's what I'd like to know." Well, it turns out he had been convicted on the testimony of a single witness, a single eyewitness, for having punched a guy in the street outside the Greenhouse on Murray Hill, who hit his head and died, and so he'd been convicted of manslaughter based on the testimony of the single witness. So I said to the defendant. I said, "Are you willing to take a polygraph?" He said, "Yeah." He passed with flying colors. So I sent out our investigator to see what he could find. What he found, a second eyewitness who who showed pictures of the defendant, said that's not the guy. And what's more, tells my investigator, that the police had shown him pictures of the defendant, and he had told them that's not the guy. That was never disclosed to the defense, and the case was tried with a single eyewitness, and he was convicted. Now, happily, I was able to get the conviction set aside, but that's the criminal equivalent. All right, now, two more cases, and two more cases I have to talk about together, because I half facetiously have said that I could teach law out of these two cases. I didn't need the rest of the curriculum. Now, the first of the two cases was a teacher salary schedule dispute. For a period of time, I was representing teachers for Ohio Education Association. And this was the dispute over where the teacher should be placed on the salary schedule. There were only a few $1,000s in issue, were it not that this was a benefit of membership free of counsel. This case was big enough to be brought. But I filed it and lost in the common pleas court, reversed by the Court of Appeals. And so my client has a few $1,000s coming to her as a result. Well, then I get a notice from opposing counsel that of an appeal to the Ohio Supreme Court. And I thought, what a dummy. Doesn't he know that Ohio Supreme Court is a court of discretionary jurisdiction and only hears cases that are significant for more than just the parties in the case? And in fact, this was a case that was so insignificant, if you were going to construct a case that least qualified for Supreme Court review, you couldn't have improved on this one. The case turned on the interpretation of a single footnote in the collective bargaining agreement. And it affected nobody else than this one lady. And it couldn't even recur because that collective bargaining agreement had expired and the new one didn't have this footnote. So, lo and behold, the court grants jurisdiction in the case. And I was just dumbstruck. What happened? So I began to look into it further. And what I discovered is that the counsel for the school district had been the treasurer for the Chief Justice's last campaign. And so when I lost on the merits only 4-3, I thought I was doing pretty well because I had no hope given that discovery. Now, meanwhile, case number 2 is taking place. And case number 2 is a criminal case in which a doctor has been convicted of selling scripts for drugs on a grand scale and sentenced to years in the penitentiary and denied an appeal bond. And I got the appeal, and I filed a motion for appeal bond in the Court of Appeals, which was denied. And the next step was to file an appeal in the Supreme Court. And not an appeal, I forget it was an appeal or a motion for bond. But I did, I filed a motion for bond in the Supreme Court, and it was denied. I then decided to make lemonade out of my salary schedule lemons by hiring my opposing counsel in the salary schedule case as co-counsel in the factual case. And so I filed a motion for reconsideration, which differed from the original motion in only 2 respects. It included the word reconsideration, and it had another name on it as co-counsel. Bond granted. All right, so we've run out of time. I have more, but unfortunately I don't have time to do it. I want to close by saying now you have some idea why I would not bet the company or anything else I cared about on litigation. And I don't, in my mediations, I don't have a lengthy speech on the virtues of settlement over litigation because if they didn't understand that, they wouldn't be there. But I did get a quote from the 18th century philosopher Voltaire that I talk about, or that I cite, and I want to tell it to you. Voltaire said, "I was ruined twice in my life. The first time when I lost a lawsuit. The second time when I won a lawsuit." So, in conclusion, with credit to Lee Corso, I have a couple visual aids, symbols of my practice. In the early years, this barrister figure with the statement, "Sue the bastards." And in the later years, this peace pipe. Thank you.